Good morning, everybody. I think we are all excited to get going in most of our country, starting slowly to get back to work. So while you're all safe sitting listening at this, let's get going immediately. So we're busy with a series on business with some business advice. So today's session is the part 2 of the Consumer Protection Act for non-lawyers. And I explicitly trying to do this in a way that well, that doesn't use all the legal terminology. I'm not going to be trying to unpack the whole legislation. It just gets hectic. I'm doing it from the perspective of a businessman. I've had to manage businesses considering the Consumer Protection Act. That's where my reference came from. I had to defend our companies against various claims and so on. And that's what forced me to really pay attention. And I'm trying to convey some of that information and some of that messages to you through these sessions, because it's really not that difficult. So what is the main objective? The objective is not for you to know the law by heart. Too many things, too big a document. But it's so that you have an understanding of the basic principles. You know what, so you know when you need more detail and where to find it. If you need help, get a lawyer, get somebody expert to help you work through it. But based on, I hope that you'll have a better understanding of when that's necessary after this. So, and before I carry on, just a quick reminder: questions, please. If you have any questions, type them in the command thing. I'm trying to leave at least 5 minutes at the end for questions. I hope I don't get too carried away and we take too long. But if there's questions that we don't get to, I'll certainly respond by email. Okay, so what did we discuss last time? It's been a few weeks with all the public holidays in between. So just a quick reminder, what we discussed last time was just a brief overview of the Act, just what is in the Act, why is it there, how does it, what's the different sections of the Act, and the headline, the main thing. If you want to comply with the Act, simple, don't lie. Don't lie to your customers and be honest. Remember, honesty is not a technical term. It's overall, don't, there's various ways you can be dishonest. Don't. It's not about just being a good person, which is always a good idea, but it's about the law. The law will catch you out if you're being dishonest. And then, of course, the National Consumer Commission has been established to assist the consumer in this. And the plumber, being the expert in his field, he will always be regarded as an expert, and he will always be required to give more information and to act more responsibly than the layman or the homeowner that doesn't know much or that doesn't understand plumbing in the expert level or on the expert level that the plumbers does. So today's section, we're going to try and look at some practical advice, some practical specifics out of this almost its standard, out of this legislation. And I try to pick some of the more contentious points, some of the more important ones. If you understand these principles, I think it covers most of what you in the trade of plumbing will experience. And I try to use some specific examples out of the plumbing trade for this one. But before we get to that, there's some legal principles we need to understand and familiarize ourselves with. The one important thing, in South African law, there's a principle: he who claims must provide the evidence. It means if you make a statement, you're the one that needs to bring the evidence, not the other way. For example, if you look at somebody and you say, you know what, I'm telling you, he always tried to steal money from his clients. Just look at the car he drives. So until he proves to me where he got his money, I will keep on saying that he's a thief. If you make a statement like that, you expect him to bring the proof to the contrary. You are in the wrong, and you might actually open yourself up to litigation. It doesn't work that way around in our law. If you make the statement, you're supposed to be able to give whatever bank statements, evidence, what evidence you have to substantiate your claim that he's the thief. The second thing to look at is a contract cannot overrule legislation. Very important one and often misinterpreted. And again, a very simple example. The labor law says that each employee must get at least 15 days leave in a year. Straightforward, you have to comply with the law. Now you employ somebody and you say, you know what, I can't afford to give you 15 days, I can afford to give you 10 days. You want the job, sign the contract, take it or leave it. That's my deal. Then the employee signed the contract, say 10 days leave, carry on. You know what? That's not enforceable. If that employee goes, takes you to the labor courts and so on, the employee will win. It's not enforceable because you cannot overrule the law. The law says at least 15 days. So no contract between yourself and the employee can overrule that. And the same applies with all the Consumer Protection Act requirements and legislation as well. The third principle, the purpose of any legislation is always considered. So when any legislation is challenged, and when there's gray areas, you don't know how to interpret what that clause actually means. Does it mean this or that? They go back, they look at the principle, what's the purpose, and use that to interpret. You know what? It just simply closes the door to try and get away with technicalities. We often hear about people that got away with a technicality. You know what? It's not that easy to get away with a technicality. Don't think you're wise and you can get away with it, while the purpose will be considered. That's also why all legislation you start, and the purpose of the legislation is explicitly detailed in the legislation. And another very important one is there's two ways that the court will look at evidence. In cases where there's criminal proceedings, something you can go to jail for life, serious stuff. The principle is typically beyond reasonable doubt. It means I can't send you to jail if there's any doubt whether you committed the crime or not, whether you killed the person or not. So there has to be strong evidence that it really was you, no doubt about it. Sort of benefit of the doubt goes to the defendant. The other principle, and this is typically liability cases, that is what they call balance of probabilities, which means what most likely happened. And I mean, it's a bit more difficult to defend, but it goes both ways. So just look at this. If you walk in, as an example, if you walk into the scenario like this, you walk in, you find this vision in front of you. Do you have evidence that kid attacked the cake? No, you haven't seen him attack the cake. There's no, I mean, he obviously is going to say, no, wasn't me, if he can speak. But the evidence, I mean, if you look at the evidence, what's in front of you, I mean, smeared with cake all over, on balance of probabilities, that baby attacked the cake. I mean, that's a principle. That is how balance of probabilities work. It's not always clear-cut black and white evidence, but it's highly likely. Why is it important to mention that? Because a lot of times people use the argument, say, oh, you can't prove this or you can't prove that. You know what? You can still be found guilty, even though it can't be proven on black and white, but on balance of all the evidence that goes with that, it might be found in a certain direction. So clause 117 in the Consumer Protection Act is explicit, and it says that for this act, balance of probabilities applies. And remember, this works both ways. It's either for or against you. It's the complainant and the defendant. Well, it's the same for both. If somebody complains against you and they use some weak arguments just to try and make your life difficult, balance of probabilities are in your favor. If you're trying to get away with things you shouldn't, then balance of probabilities goes the other way. So quickly getting back to honesty, what does this act say about honesty? Honesty as we said in the previous section, it's not just a technical term. It says don't lie and don't mislead as well. So clause 41, again, get a copy of the act, go read it. Clause 41A, you should not directly or indirectly express or imply a false, misleading, or deceiving representation concerning a material fact to a consumer. It means even if you don't explicitly tell the consumer this is wrong, or you lie directly, if you mislead them, sort of tells half a truth, the act regards that as you have lied and you misled the consumer. Don't exaggerate. It's just building on exactly the same thing. If you exaggerate on what you say, oh, this is big, or I mean, it goes the other way as well. If you don't, let's say, exaggerate, if you undersell this, if you don't tell them how important this really is, it's okay, it's not that bad. Well, it is. I mean, that is considered being dishonest. And very importantly, if you've explained from your side, and it is clear that the owner, the person, the consumer that you spoke to, misunderstands what you said, but their misunderstanding is in your favor. So I'm trying to tell you that, you know what, it's quite important. You actually should have these changes made. The owner says, well, I understand, but I don't see any danger. Let me carry on. If you can see the owner doesn't really understand it, you have to correct him. You have to make sure he fully understands. This is especially important because a plumber is seen as the expert. You as the expert will not get away with saying, well, I did tell him. You have to make sure that he understands it well as well. Section 3 in this one. Even if you falsely imply association. So let me just use the example straight away, and I'll use the PRB COC or COCs as an example. So what this section of the law says is if a homeowner says, do the work and please give me a COC. The plumber go out, he does the work, and he then writes his own COC, and he give it to the homeowner. This is misleading because the only recognized COC out there is the PIRB COC. So if a homeowner asks for a COC, the reasonable man would have expected to receive a PIRB COC. The reasonable plumber would have been expected to give a PIRB COC. If you now turn around and says, oh, but you didn't tell me you want the PRB COC, I gave you a COC. This is a false representation, it falsely make it sound like you are associated with something like that. And that is something in the legislation that is not allowed, that you're not allowed to do. And just pay attention. Right at the end, we'll tell you about the penalties and so on. And also remember, what is the Consumer Council there for, or Consumer Commission? When something like this happens, the consumer can go to the Consumer Council. It doesn't cost him anything. He doesn't have to have a lot of money. He go to the council, and the council will take this up with you, and could make you pay penalties and so on. So if you get into the slightly more technical stuff in this legislation, an example: if the owner, or how did the law work previously? Plumber does an installation, and a month or so later, there's a leak in the pipe. Previously, that owner had to find out who were wrong. He had to identify, did the plumber make a mistake? Did the transport company make a mistake? Was this damaged during transport? Was this a bad product? So the owner had to prove, burden of proof is on the owner to say who was negligent, and then he could sue that person. So it was practically impossible for the for the owner, for the consumer to really get something out of it. The suppliers got away with it everywhere. What happens now? And part of, as with the Consumer Protection Act, the homeowner doesn't have to prove anything anymore. All the homeowner has to prove is there's a leaking pipe, which is not very difficult. Take a photo, I've got my evidence, leaking pipe, done. Now, he can claim. He can take this directly to the Consumer Commission, doesn't cost him a cent. Consumer Commission, they works for, I mean, they have to show how many cases they've done, so they are motivated to get convictions. And the consumer can immediately take the plumber, claim this from the plumber. Section 61, that's the one section that you really want to go and read. It explicitly states that who is liable, who can the consumer claim the money from? The producer, the importer, the distributor, or the retailer. If you look at section 2, without getting too technical, that's a section that says, you know what, if you install anything, then you are regarded as the supplier of the product. Bottom line, as a plumber, you can't say I didn't produce or import or distribute this. You installed it, you are liable with the rest of with the rest of the value chain, which means the consumer can claim directly from you as a plumber. Let me just make sure what the section says. Okay, yes, this is about jointly and severally liable. So I'm going to skip over this one because the pictures on the next slide explains it better. You can take a note, snapshot if you want, section 113. Go and read that. It explains it, what it is, but what does it mean? What it means is that the consumer chooses who he wants to sue. So the consumer, remember our little picture of the consumer on the left-hand side, he's got to the end, he can't resolve it with a plumber. He now decides, do I claim my money from the store, from the plumber, from the factory, anybody else in the value chain? It is then between those entities to sort out where the money comes from. And remember, as I've said before, all the consumer needs to go is to go to the National Consumer Commission. The consumer doesn't need to have a lot of money with him, so in order to take you to court. It's even easier than taking somebody to the small claims court. It simply go to the Consumer Commission, and they're on the consumer side as a start. So what happens practically when the consumer now takes on the plumber, claims this from the plumber? The plumber now the plumber has to pay the consumer no matter what, because obviously the plumber is the last one that spoke to the consumer, so it's most likely that he will claim from the plumber and not try to claim from the store or the warehouse. So now it is the plumber's responsibility to claim that money back from the store, the retailer, the factory, wherever he wants, his choice again. It is at this point where the evidence that the plumber has becomes important. If the plumber can show, but when I bought this at the retailer, you showed me that it complied to the national standard. I can show you that I've installed it as per the instructions of that came with the product. I did use the correct fittings. If the plumber can show he did everything right, then he can claim that money back in the same way through this act from the retailer or the factory. Let's use a quick example. Sorry that I have to rush through this. Okay, quick example, point of use geysers. So first of all, just for a moment, remember point of use geysers, we know that they are unpressurized. In other words, open outlet, you need a special tap. You cannot use a normal mixer. It has to have that special mixer to make sure that this geyser is not under pressure. That's why I use this one as an example. So the plumber he does an installation like that and install it with a normal tap. What happens? In some time later, this thing explodes, cause damage. What does the consumer do? All the consumer needs to do is he goes directly to the Consumer Commission. At the Consumer Commission, they have the power to judge the situation. So this judge will ask you, was it installed as per the instructions or the standards? What do you answer? No, because it's an open outlet mixer and it wasn't fitted with an open outlet. It was a open outlet geyser and you didn't fit the correct mixer. So immediately you're guilty. You won't get away. Whatever penalties apply, you will be liable for. That's as simple as that, straightforward. So what can you do about it? Does that put you in a bad situation? So the plumber is instructed to replace the pre-existing geyser installed with a normal mixer. So this is where you go out, this thing burst, insurance sent you out, go replace this. What do you do when you get on site? You see, oh, there's a pre-existing non-conformance. You notify the homeowner, say, sir, in writing, have a look at this. There's a wrong tap fitted. This is a dangerous situation. It's not good. Do you want me to fit the correct tap or not? It's going to cost you. You're going to pay. You're the owner. So the owner, option one, owner will agree, and you'll make it safe, and everybody's happy. Option two, the owner refuse and instruct you to replace the geyser as it was. It's fine. Again, we're not going into that. We know you can carry on and replace it then. But then, in time, the geyser explodes or bursts and cause damage. So same thing happens. The owner told you not to fit the correct tap. The geyser exploded. Owner shouts. You go to the Consumer Commission. Now the commissioner asks you, why did you not fix it? And you tell the commissioner, well, owner insisted I don't. Okay, great. Now what next? So now the owner says, but you didn't tell me this could happen. Oh, this is where the question comes in. So the commissioner will ask you, okay, what information did you give the owner? So option one, I told him the spec said so. It's no big deal. In other words, what do you tell the homeowner at that point when you have to write the non-conformance notice? And the latest spec says so, it's not important. Is that what you told the homeowner? That means you will be liable. You will be guilty. And there's a reason I'm using this jail as the image. Can you go to jail? Just think about that for a moment. Okay, the other option would have been if the consumer asks you what information did you give the homeowner, and you said, whoa, wait a minute. I told the homeowner that that thing can explode. I told him that there's a possibility that it could damage and it could hurt people and so on. And so, you know what? Now you as the expert have done the right thing and the risk is with the consumer. It's no longer your problem. That's when you stay out of jail. But it doesn't quite stop there. So in that same scenario, the judge can say, okay, you said you told him that it's dangerous, but show me what you gave him. Let me have a look at that non-conformance notice of yours. So the one option, if your non-conformance notice just said no open outlet mixer, it's debatable whether that will be good enough, because remember the law said you can't mislead the homeowner. It's easy enough to say, you know what, that sentence, I was misled. I knew that wasn't that mixer, but I didn't know the implication. If your non-conformance notice on the right-hand side, for instance, if your non-conformance notice were explicit, say no open outlet mixer, geyser can explode, causing health and safety risks, then you really know that you are safe. And that is the ideal way. Think about this. What's the cost? What is the cost to you as a plumber to do all of this? A few minutes. Doesn't cost you anything. What does it protect you against? Quite a lot, I'd say. So, just to make life more interesting, and a very, very, very important aspect of the Consumer Protection Act. We've discussed now things going wrong. Okay, but does things always have to go wrong before this act becomes applicable? So in the same scenario, you installed the geyser using a normal mixer. You did not give a non-conformance notice, so we use one of the examples. You're completely in the wrong. But nothing went wrong yet. We know this doesn't happen immediately overnight. It takes a little bit of time. But somewhere along the line, this consumer got wise to this. The information is available, it's out there. He spoke to somebody, and he found out and said, whoa, what happened? I never knew this, that's such a dangerous installation in my kitchen where my wife always is busy and work and so on. This is completely unacceptable. What does that consumer do? All he needs to do is go to the Consumer Commission. Again, doesn't cost him a cent. He goes to the Consumer Commission, he puts the evidence on the table, say, there, that's the work that the plumber does. That's how he did it. Look, the rule says it's dangerous. And even there, even while there are no damage, no loss of life or injuries, the Consumer Commission can still find in favor or can still fine you, and you will still be liable. So what can you do about it? How do you want to make sure? You want to make sure that you have evidence when something happens, when a consumer, sometimes we know, sometimes it's reasonable, sometimes the consumers simply aren't reasonable. They just want somebody else to take the blame, and especially when it turns out that they are responsible and they don't want to accept the responsibility. So what do you do to make sure that you are in the clear? So make sure you keep evidence. The more records you keep of every job you do, the better. Consider written documents. It's not a requirement that the owner must sign for a document, but it's a good idea. Email, can get into that. Email is a legal way of communication, electronic communication. As long as you can show you send it, it will stand up, should stand up in court. It does. There's law that says electronic communication is acceptable. Verbal, yes, it is acceptable, very difficult to prove, so stay away from just verbal. Photos, great idea. I mean, you think, what else can you come up with that you can use as evidence to prove that you've done everything you can? Remember, it's about balance of probabilities. When you put that evidence in front of the judge, how probable are he to find to say, you know what, this makes sense, which I'm sure this is what happened. So the final comment, is it worth the risk? Remember the slide we had in the previous session? Is it worth the risk? It's much cheaper and easier to comply with this legislation than to try and see if you can get away with this. So all legislation has got a clause on penalties. What's the penalties in the Consumer Protection Act? And again, just go and read sections 111, 112. Safe to say you can go to jail, you can be fined up to R1 million. Remember, this is over and above damages. Damages could make this even worse. You can easily be fined 10% of your turnover. So, I mean, what's your profit margin? What will happen if you now have to pay 10% of your profit you made the previous year? Where will that leave you? What will happen if you're actually being sent to jail, which can happen? Is it worth the risk? So, to close out, the best advice I can give you as far as the Consumer Protection Act goes is, you want to stay safe, don't lie, just be honest. So that is what I had to say today, and I hope that made it did clear up some things for you. I hope that it was worth your while.